USCIS posted a major policy change today, May 22nd. If you're in the United States on a temporary status, you need to watch this episode. And separately, immigrant children who survived abuse lost their federal work permits overnight. No replacement protection. Stay with me, subscribe right now, and hit the notification bell as we go into these stories tonight. Hello and welcome to Voices with Anissa. Let me explain exactly what USCIS announced today and exactly why itself is a bombshell for millions of people. From now on, an alien who is in the US, temporarily wants a green card, must return to their home country to apply, except if there's an extraordinary circumstances. The sentence in plain sentence ends a process that has been available to immigrants for decades. Is called adjustment of status, or AOS. And here's how it worked before today. If you came to the US on an HB1 visa, work visa, or F1 student visa, or even a tourist visa, and you became eligible for a green card, you could apply while staying inside the US. You did not have to leave. You didn't have to risk being denied re-entry. You filed your paperwork, you attended your appointment, you waited, and if approved, you become a permanent resident without ever having to leave American soil. Now, that pathway for millions ends today. USCIS spokesman Zakala said, "We're returning to the original intent of law to ensure aliens navigate our nation's immigration system properly," and I have put it up over here for you guys to read the rest of it. Now, here's what it means in practice for real people, and I want you to understand this clearly. An H-1B visa software engineer from India who had been working legally in the US for 8 years, who has an employer-sponsored green card application pending, now has to leave the US to attend a consular interview in India before receiving their green card. That means leaving their job, their home, their family, traveling to a country they barely know anymore, and waiting at a US embassy or consulate with no guaranteed timeline for approval. An F1 student who graduated is working on OPT, has a job offer and a green card petition filed by the employer. Same situation: leave, apply from home, come back if approved. A tourist who fell in love, married a US citizen who has been living legally here for 2 years, same: leave, apply. The risk in all of these cases, consular processing is not guaranteed approval. The State Department can deny visa at a consular interview for reasons that would have been not raised in adjustment of status application. And if denied, you are outside of the U.S. with no guaranteed right to return. So USCIS has officially narrowed the circumstances under which will grant deferred action, making it harder for immigrants to obtain this relief going forward. Combined with today's adjustment of status change, the message from USCIS is consistent and clear. Temporary means temporary. If you want to stay permanently, the path now runs through your home country first. Immigration attorneys are already calling this one of the most significant USCIS policy changes in decades, not because it's legally unprecedented. The government argues this is a returning to what the law has always said, but the adjustment of status pathway has been so widely used for long that millions of people built their entire immigration plans around it. Those plans change today. Now, subscribe right now if you have not. Share this episode, especially if you know someone on work visa or student visa or fiance visa, whatever the case might be. This affects them directly. Now, back to it. Now, USCIS ended the 2022 the SUS deferred action policy effective May 10, 2026. Now, you might be wondering, what is the SUS children protection? What does that stand for? Now, deferred action and work permits for SUS youth waiting for green card ended earlier this month. Special immigrant juvenile status is a federal protection specifically created for immigrant children who have been abused, neglected, or abandoned. Not children who came here illegally seeking opportunities. Children who a state court, a judge had already determined cannot be safely reunified with one or both parents because of documented abuse, neglect, or abandonment. Now, these children had two protection: deferred action, a temporary protection from deportation while waiting for their green card application to be processed, and work authorization, allowing them to legally support themselves while the wait continues. Some of these waits last years of visas backlog. Now, that has ended. Their green card application still pending, their protection from deportation gone, their ability to legally work gone. USCIS is reaffirming the deferred action is reserved for truly extraordinary individual circumstances. The agency will not use deferred action as a tool for addressing groups or categories of immigrants unless specifically required by law. Now, children who survived abuse, who a court already needed, said they needed protection, who the federal judge government created a specific program to help, that program ended by policy memo. Immigration attorneys representing SUS youth are filing emergency motions in court across the country this week. They are arguing the termination of deferred action for the specific population, children who have no other legal protection available. It's both arbitrary and a violation of due process. No court has ruled yet. The children are waiting. Now, here's what immigration attorneys are also saying. We're trying to connect the dots here. The adjustment of status announced today, combined with the SUS deferred action termination, the asylum fee deadline on May 29, the USCIS enhanced FBI fingerprint check freezing green card applications, and the AR-11 surveillance form proposal represents the most connected series of USCIS policy changes in a single month in the agency's history. Each one alone is significant. Together, they are systematically closing every pathway that allowed people already inside the US to regularize their status without leaving. The message is not subtle and it's not accidental, guys. Now, before we close, I want to give you a fact. Did you know that the US had the largest immigration court backlog in its history right now? As of May 2026, this month, there are over 3.7 million pending cases in the U.S. immigration courts. At the current rate of processing, it will take over 10 years to clear the backlog, even if no new cases were filed. Ever. Now, immigration judges in the U.S., handle an average 700 to 1,000 cases per year. In comparison, immigration judges in Canada handle approximately 400. And here's one of the most, people stop cold, because approximately 70% of the people in the U.S. Immigration court proceedings have no legal representation, no lawyer, no attorney. Navigating one of the most complex legal systems in the world alone, that backlog, that caseload, 3.7 million people, they're all affected by every policy changes we covered today. Share this episode right now. If you or someone you know has a pending green card application or is in a work or student visa, they need to see this today. The rule just changed. Subscribe, hit the like button, hit the notification, drop a comment. I leave you in the care of Allah subhanahu wa ta'ala. Assalamu alaikum wa rahmatullahi wa barakatuh. Fi amanillah.